Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale, which is based on your income. That means that the less you make, the less you have to pay. Today, I wanted to take a few minutes to discuss pretrial conferences in Massachusetts. A pretrial conference is a very critical stage in the criminal justice system. It happens after an arraignment and before your case is resolved, either through a plea bargain or through trial. So, what happens is at the pretrial stage, it's a pretrial conference, that is, it's an opportunity for the defense attorneys to meet with the prosecution. That we're there to discuss the case, the strengths and weaknesses of our cases, and we're also there to get discovery back and forth between the two parties. Mostly, discovery comes from the government to us. We do have to supply some discovery, but it's much more we're trying to get information from the government. So things that we typically look for, we're trying to get. Obviously, we need the police report. We need any witness statements. We have to read the report to see what else is involved in the case. Are there any other witnesses that haven't been providing a statement? Sometimes there's video surveillance. Sometimes there's information about cell phone location and so forth. Some texts, for instance, or emails. It could be any number of things. So discovery is basically anything that's in the government's possession and control that bears on the case, especially anything which is exculpatory. And exculpatory just means that it tends to prove that you did not commit the crime that you're accused of. So the government has to turn all that over. Sometimes they're very hesitant in doing so, and we have to push them to make that information available. Sometimes they'll say that it's not within their control and that they're not obligated to turn that over to us. If it's not within their care and custody, then that's true. If it's not within their control, they don't have to turn it over to us because they don't have it. Sometimes third parties will have information that we need to get, such as surveillance video from a store, for instance, especially if it's a shoplifting case, or maybe perhaps there's records from another government agencies, perhaps from the Department of Children and Families. Maybe there's a report that would bear on our case that DCF has prepared. In that case, we would need to file what they call a Rule 17 motion. That's just a motion to the court ordering the entity, whether it's a governmental department or whoever the third party is, to produce the evidence, the information that we're looking for. If they have an objection to that, they can send a representative to the court to make that objection. If they feel that it's confidentiality situation, or for whatever the reason might be, they can make that pitch to the court that they don't have to turn that over because of some reason. And we would obviously argue against that because we want to get all the information that we can. One thing to watch out for is in the situations like that is we don't want to ask for any information that the Commonwealth doesn't have that would tend to be inculpatory, which means which tend to show that you did commit the crime. So, for instance, sometimes we hear that there's a video surveillance from somewhere, either like a ring.com type thing where somebody's home shows whatever took place. And sometimes the client will say, oh, yeah, there's video. You got to get that. It's going to show that I wasn't there or that it didn't happen the way they're saying. The Commonwealth doesn't have that. We don't want to order that information. We order that to be subpoenaed, to be brought in if it's going to be harmful to us. So we want to be very, very, very careful that we're not opening up a Pandora's box and we're asking for something that's ultimately going to harm our case, because that would just obviously backfire on us. So that's a Rule 17 motion. At the pretrial stage, we're also discussing usually what are the possibilities of resolving the case short of trial. What would the government offer as a plea bargain? Are they asking for committed time? That means jail time. Are they just looking for guilty probation? Can we get you a continuation without a finding? Would they be willing to dismiss the case? Those are rare, but sometimes that happens. So we're always negotiating with the government to try to get us in the best possible position if you want to plea out to the case in some fashion rather than take it to trial. Usually, there's a number of pretrial conferences throughout the course of your case. So the pretrial conference is very common, and it happens frequently, even within one case. When you get through with the pretrial conference, at some point you have to elect whether you're going to take the case to trial or if you're going to dispose of it by way of a plea. We've discussed a little bit of that in other videos, so you might want to check those out as well. At Afford Law, we do practice criminal and family law throughout Massachusetts, and we do so on a reduced rate. Basically, all of our fees are based on your income, so the less you make, the less you have to pay. Feel free to visit us at affordlaw.org, and while you're there, please feel free to give us a call and book a free virtual appointment with me. I'd be happy to answer any questions you might have about criminal law or family law in Massachusetts. At Afford Law, we're making justice affordable.